My Lords, given the time constraints, I'm intending to give you references for a number of the documents rather than actually asking you to turn them up. Given that there doesn't seem to be any dispute as to what the documents are and so forth, I hope that's going to be an efficient use of time. My Lords, can I ask you to turn, first of all, please, to our further supplementary authorities at tab 4. That's further supplementary MS 82 and following. This is, forgive me.
Is this Rule 1910 definition?
Yes. Yes, my Lord, tab 4. That's MS 82. And in fact, the relevant bits start.
Sorry, is this from Spencer Bar?
No, it's this.
Oh, it's further supplementary.
This was the preceding further supplementary authorities.
Page 82. Page?
I think 83 we can start.
Yes.
82 is simply the definition of a GLO. This is to provide for the case management of claims which give rise to common or related issues of fact or law, the GLO issues. 1911 deals with the making of a group litigation order where there are likely to be a number of claims giving rise to the GLO issues. And sub-rule 2 says that the GLO must contain directions about establishing a group register, and B, specify the GLO issues which will identify the claims to be managed as a group under the GLO. If one then goes to MS 85, there one can see what CPR 1912 provides about the effect of a GLO. Where a judgment or order is given or made in a claim on the group register in relation to one or more GLO issues, A, that judgment or order is binding on the parties to all other claims that are on the group register at the time the judgment is given or the order made, unless the court orders otherwise, and B, the court may give directions as to the extent to which that judgment or order is binding on the parties to any claim which is subsequently entered on the group register. And then importantly, sub-rule 2, unless paragraph 3 applies, any party who's adversely affected by a judgment or order which is binding on him may seek permission to appeal the order. 3 provides in broadly equivalent terms that where a party was entered on the group register after the judgment or order, he can't appeal it, but he can apply for an order that it's not binding on him. So the first and most important thing in my submission in group litigation is to identify and define what the GLO issues are, because those identify what claims are to be managed as a group and therefore enable potential participants to decide whether to participate in and contribute to the funding of the group litigation. One thing which follows from that in my submission is that even if Mr. Ewart were right in saying that there are no defences to any other claims, which isn't quite right, as I'll explain briefly in a moment, that wouldn't really take matters further forward, because the effect of 1912 would be to apply the judgments or orders on GLO issues of the Court of Appeal, and subject to them, the judgments or orders of Mr. Justice Henderson on GLO issues across all other claims in the GLO which share common issues of fact, law, or both with the BAT test case.
Unless the court otherwise orders.
Unless the court otherwise orders.
I mean, trying sort of jumping ahead, I mean, if we were to decide that issue 28 had a certain result in these proceedings, but we didn't know how it affected all the other proceedings, we could presumably decide the issue and then delegate to a lower court to try and sort out where we went from there.
Yes, I mention this at this stage because I'm embarking on my run-up to an answer to my Lord Sales's inquiry.
No, I understand it, but I just wanted to see where I might be going at the end of it all. Yeah.
So, in fact, there were some defences. I don't need to get into this in detail. There were some defences because in December 2014, 7 claimant groups issued summary judgment applications on part of their claims. That had the effect of lifting the stay of those claims under the terms of the GLO and caused the period for filing a defence to begin, but there was a permissive extension because applications for summary judgment were pending. Those applications were resisted by the Revenue on various technical grounds, and perhaps I can just give you the reference for the judgment on this, which is at Core Volume 2, 703, which is MS 4748. The Revenue resisted on various technical grounds, as one sees at paras 64 to 80, and on the basis that they had a realistic defence on various issues. That's at paragraphs 15 and 55 to 58. But there was no limitation objection taken. And in fact, Mr. Justice Henderson recorded, this is MS 4767 at para 52, that nothing turns for present purposes on the requirement that the claims be within the applicable limitation period. That's because it was accepted that they were. Summary judgment was granted save in relation to compound interest. That's MS 4199 to 4202. The stay was then reinstated. Of those 7 claimant groups, 3 had claims which were the subject of the summary judgment applications and would have been out of time on the Revenue's current arguments. There were then 12 further summary judgment applications, both on FID claims and more generally. They also had a suspensive effect on the Revenue's obligation to serve a defence. 5 of those applications were in claims which predated the 8th of March 07. No defence was filed on those, and no limitation point was taken, and judgment was entered. By contrast, and this may be significant, in the claims for summary judgment in respect of proceedings issued after the 8th of March 07, defences were filed by the Revenue in which there was a non-admission as to whether the claims were within time. So we say that the absence of defences doesn't really take matters further forward, but the fact that no defences were served and no limitation point taken in respect of those proceedings issued before the 8th of March 07, whereas defences were filed containing a non-admission that the claims were brought in time in respect of those issued after the 8th of March 07 is consistent with issue 28, when we get there, being restricted to the binary question of whether the date of constructive discovery was 2001 or 2006. In any event, where one gets to from those provisions of the CPR is that the decision in a test case is binding on all the other claims on the register at the time of the decision, unless the court orders otherwise. There's a facility for an adversely affected party to seek permission to appeal or to apply for an order that the judgment or order doesn't affect him. But this is the important point, my lords. The affected party who seeks permission to appeal or an order that the decision isn't binding on him does so in his own separate case. The decision in the test case remains binding as between the test claimant and the defendant, and indeed on all those other claimants on the register who don't appeal or apply for an order that the judgment shouldn't apply to them. And we say that, when we get there, is a highly material factor in terms of prejudice, the prejudice which BAT and others will suffer if the Revenue's approach to this appeal is condoned by this court. The approach generally to GLOs and the undesirability of points being relitigated in a GLO context has been considered in 2 cases, one of which is the Chancellor's decision in Class 8, and I'm just going to give you the reference. It's MS 1869 to 1935. There were 2 particular issues which the Revenue sought to raise, which could have been taken in the prudential test case, and the Chancellor declined to allow those to be argued on the basis there must be finality to litigation. The GLO process has been established in order to facilitate that outcome. One sees that at paragraphs 131 to 133 and 142 to 144. The other case is a decision of Mr. Justice Henderson. I'm not going to ask you to look at it now, but it's at our further supplementary authorities tab 3. So that's further supplementary MS 71. It's the ACT group litigation, domestic decision of Mr. Justice Henderson, where he said at 87, I just mention this because it's quite a vivid description of what the GLO process is not intended for. He said, the purpose of group litigation is to promote the orderly and efficient resolution of multiple claims which involve common issues of law or fact. It is not intended to provide test claimants with a laboratory in which they can try out one new argument after another until they finally hit on one which meets with the court's approval. And we say, save that it's defendants rather than claimants, that has a very striking resonance with the circumstances which we now find ourselves in.
Can I just ask you, the judgment you took us to a moment ago at the back of Core Volume 2 is, seems to be concerned with FID claims. But it looks as though they form part of the same GLO as the FII test claim.
There are FID claims in this GLO, separately from what your lordships were told about a separate GLO, the FID GLO, all of which has been part essentially for jurisdictional grounds.
Is there somewhere where we can? One of the most difficult things in this litigation is to be clear in your mind as to who's who, particularly when, for example, Höchst, I think, is actually somebody else in one of the other. There are two cases with different names which are actually the same party, and they changed their name. Is it Sempra and Höchst? Yeah. Is there somewhere where there's a clear explanation of what the different GLOs are?
If there is, those behind me will look for it.
Yeah, I suspect probably in one of Mr. Justice Henderson's judgments he may have explained it all, but...
We can create it.
We'll make inquiries, and if it doesn't exist, we can create one. I'm sure we can agree that between the parties.
Yes. Thank you.
So it's against that background, I'm going to take a rather hurried canter through relevant aspects of the history. The key point for me to emphasise, my lord, is that by contrast with my own friend Mr. Hewitt's suggestion, that actually the way in which the litigation was structured always contemplated that limitation issues would be taken at this stage of the litigation, or variously, his slightly different suggestion that actually each stage of the litigation has addressed a congeries of assorted issues taken almost at random, such as to be, as he put it, in substance, if not in form, a trial of preliminary issues at the first stage. The true position is that there was always a clear demarcation between liability and quantification. And that goes all the way back to the early case management orders made in 2003. And that follows through to what was decided by Mr. Justice Henderson in HC1, by the Court of Appeal and the Supreme Court in the first liability stage, and similarly into the second stage. May I just give some references to descriptions in judgments, including by Mr. Justice Henderson and by the Court of Appeal, of that split in the High Court Summary Judgment. This is MS 4748 to 4777. There's a reference at paragraph 3 to the English liability proceedings and to the quantification proceedings. And then there are similar references at paragraphs 6 and 8, referring to the Court of Appeal's decision in the pleadings appeal, and 45. So that's MS 4751, 4753, and 4765. Similar references in HC2 at paragraphs 2, 4, 13, 76, 178, and 290. And in CA2, that's MS 4199 and following at paragraphs 10 and 11. Those reflect, not least in the perception of Mr. Justice Henderson, how the proceedings were always structured. I am going to ask your lordships, if I may, to look at one document for now. That's the GLO itself, which is at Appendix 1B 978 and following. That's MS 5023 to 5047.
Sorry, say that again.
It's MS 5023 is where it starts.
This is the Technicolor version.
This is a technical version.
Yeah.
And if one goes to Schedule 3, the issues, that starts at 5033. One sees the GLO issues, as we've just been discussing in terms of CPR Part 19, set out there, and at MS 5036, 2 issues on limitation. P, from what date does the limitation period commence? And Q, and you can see the original form which is struck through, concerned the amendments to Section 32(1)(c) made by Finance Act 2004. That was subsequently amended after Section 107 to address the amendments made by the Finance Act 04 and Finance Act 07. But the most important thing to note is the breadth of the original GLO issue Q. From what date does the limitation period commence? The fundamental issue for limitation purposes that concern everybody, not just those who'd issued their claims after the 8th of September 03, was the date from which the limitation period commenced. We say that if one looks at those issues, that's crucial in terms of identifying what happens subsequently, because if one then goes to the order of Mr. Justice Park of the 12th of December 03, I'll give you the reference if I may, it's MS 5048 to 5052. It's in Appendix 1B, starting at page 1003. He ordered paragraph 2.2, the BAT claim shall proceed as test case for classes 1 and 2 in relation to issues A to P, so that included...
Sorry, I'm not with you. Which page are we on?
It's
5049.
5049.
5049.
5049.
Thank you, sorry.
So 2.2, BAT proceeds as a test case in relation to A to P. Aegis, which issued its claim later, shall proceed as test case in relation to issue Q. And then 2.6, at the bottom of that page, save for the quantification of the amount of damages and compensation, and subject to paragraph 2.5, which was a stay in relation to issues H and K, all GLO issues raised by the test claims, including liability for restitution, shall be heard together, the specified GLO issues. So that's a clear demarcation in my submission between quantification and liability. And that follows through, I'll just give your lordships the reference, into the order of Mr. Justice Reimer from July 2007. That's at MS 5053 and following. I just replicated what had been provided in Mr. Justice Park's order. So those were the GLO issues which came before Mr. Justice Henderson in High Court 1 in 2008. The revenue skeleton for that hearing recorded their position as being, this is MS 5771, that they were relying on Section 320 and Section 107 as displacing Section 32(1)(c). They also said in paragraph 181, this is MS 1731 to 1732, referring back to DMG, that as a result of DMG, but for Section 320, claims for repayment of tax dating back to entry into the community in 1973, which had previously been time-barred, would have been available so long as they were commenced within 6 years of discovery of a mistake. Now, in terms of what was actually decided, Mr. Justice Henderson's judgment records, beginning at para 267, so that's MS 4296, paragraph 267, my lord, beginning at 267. The unlawful payments of ACT made from 1973 to 1999, and the unlawful payments of ACT made under the FID regime from 1994 to 1999 were, in my view, plainly made under a mistake about the lawfulness of the tax regimes. I'm satisfied from the evidence this wasn't obvious to anybody within the BAT group at the time. It is only now, this is the bottom of 267, it's only now in light of the decision of the ECJ that a mistake can be seen to have been made. That wasn't appealed. Then he follows through that reasoning in paragraphs 268 and 269 in relation to ACT.
Those are findings of fact on the evidence.
Those are findings of fact on the evidence.
You say not
In relation to when BAT was in a position to appreciate that the tax wasn't lawfully due. If one then looks at Mr. Justice Henderson's order following HC1, one can see how those various GLO issues were disposed of. The order starts at MS 4151.
Sorry,
4151.
415.
Can I just ask you, I mean, is this in your case in this degree of detail, or if not, do you have it all set out in writing somewhere?
Well, the factual material relied upon is not entirely,
Well,
but
I'm
mostly in
not-
the annex to the written case.
It's just that it would be very useful. I mean, obviously you can dig around in the transcript and find it, but if you have it in a convenient form, it would be very useful to have it.
Well, it's presented thematically in the annex to our written case. I'm trying to set it into a chronological context in order to explain how it was that issue 28 ended up.
It would be very useful to have that in written form at some
That
point.
can obviously be done, my lord. So the first point to make, 4151, is the first recital, the trial of all GLO issues raised by the test claims, including liability for restitution, save insofar as those issues concern causation or quantification of the claimant's claims. Bottom of 4153, declared that claims for unlawfully levied ACT specified in certain paragraphs would fall within the scope of a mistake-based restitutionary claim. Similarly, in paragraph 17, unlawfully levied ACT and or corporation tax under D5 was paid under a mistake. And then the order provides paragraph 1, the following claims are successful in relation to the GLO issues determined in the trial. A, claims for repayment of corporation tax paid on or after the 1st of January 1973. B, repayment of surplus ACT or time value of utilised ACT paid on or after the 1st of January 1973. And C, it's the 1994 date because that's when the FID regime was introduced. There was a further refinement of what was actually in issue in terms of the GLO issues prior to the first Court of Appeal hearing, and those are actually to be found in the schedule to the Court of Appeal's order. That relevantly is at MS 4164. Where issues 20, 21, 22 and 23 are concerned with, amongst other things, the application of section 320 and section 107, and whether that was precluded, the application of section 32(1)(c) to repayment or damages claims, and the impact in terms of jurisdiction of section 33. So my submission is that as the formulation of issue 22 reflects, it was common ground that, subject to section 320 and section 107, the claimant's mistake claims benefited from the extended limitation period under section 32. And if I could just give your lordships the reference to what the revenue was saying about limitation in their skeleton, that the relevant portion is at MS 5793. Paragraph 68, they said that the test claimants had three potential causes of action under domestic law: the Frankovich claim, the Woolwich claim, and a restitutionary claim for money under a mistake of law. And then in 69, there's a discussion of section 32(1)(c), and it recites that it's common ground that 32(1)(c) applies in principle to the test claimant's action for money paid under a mistake of law by virtue of Klein-Benson. The question is then whether the application of 32(1)(c) in this context is precluded by 320 and 107. My first point is there was never any suggestion, as one might gather from the revenues written case and reply, that issue P or issue Q was being hived off to the second stage of the proceedings. Still less that there was any sort of agreement at that stage that that's how the proceedings were to be structured. And indeed, when the issue of limitation came before this court for the first time, one of the issues for determination, as Lord Walker put it, was the correct construction and scope of section 32(1)(c). Again, the datum from which all the argument proceeded was that, subject to section 320 and section 107, the extended limitation period applied. If I can give your lordships a couple of references to show exactly what the revenue was saying about that. HMRC's objections, this is MS 5797, recorded that if the test claimant's arguments on issue 20, that was in relation to section 320 and section 107, were successful, they can then rely on restitution for mistake, including section 32(1)(c). And if one looks at the revenue's amended written case, in particular, paragraph 3C at MS 5810, paragraph 31 at MS 5812, and in relation to the curtailment of the extended limitation period at 105, which is at I'm afraid I can't find a reference for that, but I'll come back to it. It's clear that the revenue's position was that, in principle, section 32(1)(c) applied. Now, the next point to make about the first time that the case came before this court is that there was no suggestion that the revenue had any intention of challenging DMG at a later stage. There was no reservation of their position and no suggestion that the way in which the proceedings were split between liability and quantification would justify a point being taken later. And the point was specifically raised in the transcript. One sees, this is MS 5820 to 5821, that Mr. Aronson is recorded as saying no one is challenging DMG. Lord Brown said no, and the revenue didn't say anything to the contrary. At MS 5829 to 5830, Mr. Rabinowitz was talking about a lot of the litigation being about the revenue trying to row back the effect of DMG so as to remove section 32(1)(c). But he goes on to say, but your lordships, unless someone says that DMG should be overruled, and certainly the revenue are not saying that here, we do live in a world where there is a DMG remedy. And then perhaps most significantly, and this is at MS 3995, the transcript records whenever Mr. Ewart saying, supposing you were to decide, and I'm not inviting you to do so, but supposing you were to decide that you wanted to exercise your rights under the practice direction and say that DMG was wrongly decided, would that be permitted under EU law? We say that that is on its face an express disavowal on the part of the revenue at that stage of any intention of challenging DMG.
Can you just give me that last page reference?
My Lord, I think it's MS 3995. That's to our annex, forgive me. I think the appendix reference to the actual document is MS 5849 to 5850. The matter was then referred to the ECJ for the third time. The Learned Friend Mr. Aronson asked your lordships yesterday to look at the order for reference. So I'm not going to go there now, but one can see expressly recorded there that were it not for Section 320 and Section 107, the test claimants would have been entitled to rely upon Section 32(1)(c). One then gets the judgment in ECJ 3, where the Court of Justice held that the limitation period started with Herx on the 8th of March 01. That's MS 5016. And what then happens, and this is where one leaves the foothills and gets slightly closer to the summit in relation to answering my Lord Sales's question, one then gets those comments being picked up after the trial in High Court 2 in annotations made by the Revenue to the list of issues for that case, which was submitted more than a month after the trial. I'll come back to that in a moment. In the meantime, the Revenue amended their defence. My Lords saw that yesterday. The amended defence, which remains the Revenue's current defence in the BAT claim, admits that the claimants made mistakes of law. That's paragraphs 32 and 57b, and admits what was pleaded in the 13th amended particulars of claim, paragraphs 18 to 18c, which is all about Section 32(1)(c and the either-or 2006 or 2001 dates, and expressly admits that the claimant's mistake claims are not time-barred. So that was the Revenue's pleaded case when the matter came back before Mr. Justice Henderson in 2014 in High Court 2. And there, one sees that ultimately there was no limitation defence run at all against BAT, and the admissions that had been pleaded by that stage came to be reflected in the parties' agreed documents for High Court 2. Perhaps I could just mention, my Lords, the references to the GLO issues which were before the court in High Court 2. They're in the Schedule 1 to Mr. Justice Henderson's order of the 30th of January 15. That's MS 4191 to 4196. What we say is that issues 1 to 16, 25 to 26 and 29, so that's 19 out of 29 issues, all clearly relate to quantification and how the ECJ's decision should be given effect in terms of quantum. Issues 19 to 21, change of position, were expressly reserved to the second trial at the first trial. One sees that in particular from paragraphs 189 to 193, most particularly paragraph 190 of the Court of Appeals judgment MS 4429. Although when it came to it, Mr. Justice Henderson concluded that he'd answered issue 19 first time round and declined to reopen it. Then there were two issues, or two sets of issues in relation to topics which were raised for the first time in the Revenue's re-amended defence in February 2014. They hadn't been raised in the defence before High Court 1, and that's why they didn't come up in the first trial. And those are issues 17 to 18 in relation to shareholder credits, and 22 to 24 in relation to actual benefit. And that leaves just two limitation issues, 27 and 28. 27 asked for confirmation as to what years gave rise to valid Woolwich claims. That was uncontroversial at the time, although it's now sought to be challenged this December. And then issue 28. And the issue of the genesis of issue 28 being addressed in that case can be seen in correspondence with the judge after the draft judgment was released. issue 28 was intimated in the lead-up to High Court 2 as an issue which the revenue might raise. We said in our skeleton it had been decided and would reply if the point was actually taken, but our position was that it didn't arise. Having seen the statement made in paragraph 267 of Mr. Justice Henderson's first judgment, it's only in light of the decision of the ECJ that a mistake can be seen to have been made. That, in my submission, was an entirely understandable position for the claimants to take. And of course, it's accepted that, as regards BAT, there was no limitation point run. In the end, there wasn't any argument at the trial on the part of the revenue in relation to this. There were no oral submissions or written submissions, and it was only in the post-trial annotated list of issues that there was any submission made in relation to issue 28. And if I could ask your lordships to look, please, this is at MS 5942 and following. There's a letter there of the 11th of December 14 from Mr. Aronson.
I'm sorry, can you give me the page again?
Sorry, 5942.
Ah, right.
Second paragraph, until shortly before the hearing in May, June 2014, the claimants had understood it to be common ground that the relevant date on which the claimant's mistake good with reasonable diligence had been discovered was ECJ 1, 12th of December 06. That understanding was based on the pleadings. The claimants pleaded primarily they couldn't discover their mistakes with reasonable diligence before 06, and alternatively March 01. That was admitted without qualification. Over the page at the top of 5943, in the run-up to the May-June hearing, and in particular in the course of agreeing the statement of facts and issues, the claimants learned that HMRC wished to argue that the relevant date was March 01. Although the earlier date would have no impact on the test claimants' claims, it would lead to the claims of a number of other claimants being time-barred. It was therefore included in the agreed list of issues for the hearing. The claimants weren't sure whether the revenue wanted to run the point. They confined themselves in their skeleton saying they'd deal with it in reply, but they also said it had already been decided, and according to the pleadings was common ground. And on that basis, they didn't deal with the issue in their submissions. There was a contention at the bottom of the page that if the revenue wanted to argue the point, they needed to amend, bearing in mind the admission made and the fact that the point wasn't argued.
Sorry,
forgive me, my lord.
the admission was of a pleading of two dates. It was either one or the other.
Neither of which had any impact on BAT's claims.
Right. So I'm just not quite sure why it's being said that somehow the revenue were fixed with the later date.
I think for present purposes, and indeed for the purposes at the time, there was no issue from BAT's perspective which date it was. There's an issue in relation to other claimants,
yeah.
But in relation to, I think, 19 out of the 27 claimants, it didn't matter whether it was 01 or 06, but there were another 8 who were affected, and that's the point addressed at the top of MS 5944. Counsel for the Revenue then wrote to the judge, that's at 5945. No pleading points were taken up until after the draft judgment was released. Issue 28 was of no practical significance for BAT, therefore the defendants didn't seek to amend their pleadings. Both parties understood that issue 28 was of practical relevance for other non-test claimants, and therefore agreed that it should be one of the issues to be decided in the trial. And then the judge replied, Mr. Justice Henderson's letter or note is at 5946 to 5947, referring to the fact that the list of issues had been submitted to him over a month after the end of the hearing, saying he didn't regard the pleaded position as between BAT and the revenues to be relevant because precisely because everybody agrees that the answer to it makes no difference so far as they're concerned. And if I can just give the references to the most relevant paragraphs of Mr. Justice Henderson's judgment in HC2, that's at MS 4611 and following. It's paragraph 5, where he talks about the position being finally reached that the Revenue's attempts to confine the test claimant's mistake-based remedy to 6 years had failed. Paragraph 250, paragraph 336, and then, most crucially, issue 28 is addressed at paragraphs 452 to 470, where it's described as an isolated question, which is raised because it was apparently left undecided in High Court 1. Our position remains that it was in fact decided in High Court 1, and it may be that it was the rather odd way that it then resurfaced after High Court 2 that led Mr. Justice Henderson to come to that view. But he reiterated that the answer to it isn't...
But sorry, Mr. Justice Henderson's position, it's not right, was that it has not been decided by him. Isn't that what he said in his letter?
Yes, exactly. And that's what I was saying there. Our position is that it was decided. Our position before him was that it was decided in that correspondence. He said there it was apparently left undecided, and that is the view that he took. He hadn't, in fact, decided it first time round. But if one looks at paragraphs 267 and following in that first judgment, it rather looks as though he had decided it. That was the subject of that correspondence. But the answer to it, he records, is of no practical significance for the BAT test claimants.
Why? If there's doubt whether a judge has or hasn't decided something, isn't it relevant to look at what the judge thinks he's done?
I'm not suggesting otherwise, my lord. One sees there, when he talks in 452 about it being apparently left undecided. I'm not suggesting otherwise, my lord. I'm making the point that we had proceeded through the second trial on the basis that it had been decided, but as one's seen from Mr. Aaronson's letter to Mr. Justice Henderson, the parties do seem to have identified that there was an issue which would affect some non-test claimants, as between 01 and 06, and effectively as a sort of practical expedient, it seems, had intended that that might be raised. It's just that from the test claimant's perspective, it seemed not to have been raised by the Revenue until a month after the trial. And then one gets, my lords, to a very important document, which is the order of Mr. Justice Henderson from January 15. And that's where one has two declarations answering issue 28. This is at MS 4174 and following. (4178), top of the page, just under 19, one sees, it's hereby declared that the GLO issues are answered as follows. And if one goes forward to 4185, issue 28 is answered in two parts. The date when the claimants discovered or could with reasonable diligence discover their mistake is 8th of March 01. B, it's common ground that on any view, the BAT claimants started their mistake claims within the extended limitation period. As a result, all of the mistake claims of the BAT claimants dating back to 1973 are in time. 24B was never appealed, and that we say is utterly unsurprising because, of course, the parties were in agreement that BAT's claims had been brought in time. Indeed, the parties were in agreement that the BAT's claims had been brought in time until 2018, 2 years after the permission to appeal application was submitted. Now, importantly, we say that the effect of CPR 19.12 is to extend that conclusion, 24B, to the other claims in the GLO issued within 6 years of Höchst, because that, subject to an order to the contrary, is a judgment or order in a test case which is binding on all others with shared issues of fact and law. So the order is saying, in line with the judgment, that claims like BATs are in time if issued within 6 years of 2001.
Specific conclusion in relation to the position of BAT.
My Lord, I think the position that the parties were taking was that it was a decision in a particular case that alerted them and anybody else, or put them on a duty of inquiry in terms of exercising reasonable diligence to bring their claim, and that wouldn't have made any difference. There was no other factor but for either the decision in Herxt or the decision of the ECJ in this case that engaged the limitation period for anybody. So it would have applied to anybody who issued their claim within the 6 years.
I mean, there seems to be a distinction between A and B. A talks about the claimants and B talks specifically about the BAT claimants. Is there any significance to that?
My submission, no, my Lord. The point is, what's true for the BAT claimants is true for the other claimants who brought their claims within 6 years of the 8th of March 2007.
I'm just quickly scanning back through the parts of the order answering the GLO issues. They all seem to be posed in terms of the claimants rather than the BAT claimants. And then at 24B, there's a specific focus on the BAT claimants. And then again, it's hereby ordered that one's back to, I think, BAT claimants. And the impression one gets is that insofar as GLO issues are being answered, the order refers to the claimants, but when it's specific to the BAT claimants, it talks about the BAT claimants. Is that right?
Well, that's not a distinction in terms of certainly paragraph 24 that we would have identified. The distinction was between those who'd issued their claims by a particular date and those who hadn't. Very briefly, while we're on the order, I should mention...
I see in paragraph 11 of the order, the claimants are granted permission to cross-appeal. So the claimants there seems to be referring to the test claimants, not every claim.
Those are the parties. I mean, it was the BAT group that brought the appeal.
Yeah, and also the forward claimants.
Can I just... I think Ford was in the position of being within time on the basis of that date. So
No, I'm just wondering, were they amongst the test claimants? Yeah. In other words, there were test claimants who weren't BAT claimants. Well, I don't want to take up your time with this, but obviously we need to know who actually are the parties to the various proceedings that we're dealing with, particularly if there are issues about res judicata and so forth.
While we're here, paragraph 13F of that order defines the back claimants.
13F.
Right, so are the back claimants the claimants in a BAT GLO? Is that?
no, they're the claimants in this GLO who belong to the BAT group.
Oh, so it's the
And
specific
they are the
BAT
test, and they are the test claimants.
Right.
involved.
Yeah.
To 24B is referring specifically to the BAT group.
Yeah, paragraph 1 defines the back claim.
Yeah.
Right. Sorry, I'm just trying to get to grips with this order, reading it for the first
But
time.
who are the others in line 2 of paragraph 1?
In relation to the second Court of Appeal case, the revenue skeleton didn't address issue 28 at all. If one goes to the transcript, MS 5984, one sees their position was simply that Mr. Justice Henderson was right for the reasons he gave. One also sees in the argument Professor Burrows saying it's fine to have the extended limitation period, but you need to have the concomitant burden of a change of position defence. And then importantly, my lords, it's MS 6002 and following. There's there's an exchange with my learned friend Mr. Ewart. The passage at 6002 to 6003 is where my learned friend Mr. Ewart talks about there being no run-up to Herxt, or agreeing with Lord Justice Underhill, there was no run-up to Herxt, it was a thunderbolt, it changed everything. And that puts a rather different complexion on the revenue stance at that hearing from what was said by my learned friend Mr. Ewart and his submissions by reference to the transcript, all of which we say shows that there was no marker being laid down of an intentional part of the revenue to challenge DMG in this court. What was potentially in contemplation was some future debate in relation to the interpretation of DMG or the modification of GMG so as to arrive at a date of 2001, not a full frontal challenge to DMG and Kleinwort-Benson. And that, of course, is borne out by the fact that when permission to appeal was sought in 2016, the Revenue's position was that they were looking for a 2001 date rather than a 2006 date. And there was also a recognition, acknowledgement in the transcript that the reason why the BAT defence hadn't been amended was probably because it made no difference in this case. And then the judgment of the Court of Appeal records the fact that the pleaded position of the Revenue was to admit the relevant paragraphs in full, that the BAT claimants' claims were comfortably in time, and so forth. And when one gets to the order of the Court of Appeal, one sees that there is an amendment to Mr. Justice Henderson's order in relation to Declaration 24A, because the Revenue had succeeded on that. But there was nothing said there. This is at MS page 4047. Page 4047, my lord. Nothing said there about 24B, because it wasn't appealed. Because at the time it was common ground that the BAT claimants' claims were in time. Moving on to the question of prejudice in the limited time that's left. The most important point is that decisions have been taken in this litigation on the strength of the Revenue's admission. BAT relied upon express admissions that there was no limitation issue being taken against them, when, as the test claimants, they appealed Declaration 24A on issue 28 to the Court of Appeal for the benefit of other claimants who were affected by it. There is no way that they would have appealed if there had been any inkling that the Revenue might later seek to withdraw those admissions, converting what had been a narrow binary issue 2009 versus 2006, which was acknowledged to be of no practical significance to BAT themselves, into one with the potential to deprive them of 90% of the value of their claim. If they hadn't appealed, there would have been a final decision in respect of their claim at High Court level, and the matter for them would have ended there, never reaching the Court of Appeal or this court. The answer to issue 28 from their perspective would have been entirely benign, 2001, and it would have been binding on them and other claimants whose claims were issued within 6 years of 2001. Whether that 2001 date was then challenged by other claimants seeking to appeal in their own separate cases would have had no impact at all on BAT. Now, Mr. Hewitt responds by saying, well, the revenue could have responded, could have appealed, but it's well established. The case we rely on is Lake and Lake, which is in supplementary MS, page 52, the relevant paragraph. We rely on that and the disposal of the revenue's application to permission of appeal to this court on issue 6. This is MS 3890, for saying that if the revenue had tried to appeal against an order that was in their favour, they wouldn't have got very far, just as they didn't in relation to issue 6. So the matter, so far as BAT is concerned, would have ended there. And that, in my submission, is a very substantial kind of prejudice to which claimants and others aligned with them are subject. Also in relation to prejudice, your lordships have heard from Mr. Aronson about the 45% tax rate, specifically imposed because there was going to be a windfall in terms of compound interest and the operation of the extended limitation period, whereas in fact, as things now stand, it seems that the claimants will suffer the windfall tax without obtaining either aspect of the supposed windfall. Littlewoods and Prudential have both been determined in part on the basis of the availability of the extended limitation period. That was a matter relied upon to justify restricting the interest available. For how Littlewoods was argued on that point in the Supreme Court, I think it's page 631. It's Appendix 3, tab 73. And I can give your lordships the references to the decisions themselves. It's Littlewoods, which is MS 622 to 623, the relevant paragraphs 57 to 59, and Prudential, relevant paragraphs are at MS 754 and 755, that's paragraph 62 and 65. There's the need for factual findings and the need for a retrial, which I think is now, depending on how the case is decided, if decided differently from below, it's now acknowledged that the need for factual findings and a retrial, which will be the fourth trial of these proceedings after some 16 and a half years. That is plainly hugely prejudicial. Permission to appeal was given in...
Sorry, when you say need for a retrial is now acknowledged?
I thought I understood from Mr. Hewitt yesterday, depending on which of the variants of his case is accepted, there may well be a need for findings of fact in relation to knowledge of claimants.
I thought his primary, or one of his cases, was that since the legal materials were all available and known as from the date of the Herx judgment, that's the relevant date.
This case is manual, yes.
Okay,
I'm not sure it's all.
I just wanted to check I hadn't misunderstood at this
Yeah, I
point.
mean, your point is that if it's sort of the middle ground, sort of somewhere between
The floating middle.
the floating thing, then you would be entitled to call, once one's identified what the point is, you would be entitled to call evidence on the state of knowledge at that time.
Precisely. Briefly, permission to appeal was given by the Chancellor in Class 8 on the basis that the revenue would not be arguing in this case for a date of constructive discovery before 1997. Can I just give you the reference to the transcript of the permission hearing, which is at MS 993 to 994, where my learned friend Mr. Hewitt is recorded as saying that the issue that he was seeking to raise there wouldn't have been relevant in Prudential because they brought their claims in 2003. So we would have had to have been arguing that they ought to have known before 1997, and that is not part of anyone's case. No one is suggesting constructive knowledge occurred as far back as that. That was the position that was being taken as at March of last year. So one sees clearly the further development or mutation of the revenues case since then. And lastly, and I have both eyes on the clock, costs. We recognise that costs are a factor to be weighed in the balance, but not necessarily conclusive. But can I just give your lordship some information in relation to those costs? Since the revenues admission was made that our claims were in time, hearings in the main test case dealing mostly with quantification have taken up 18 sitting days in the High Court, 10 days in the Court of Appeal. In relation to the windfall tax, which the participants in the GLO agreed to fund the challenge to because it was considered relevant to all of them, there have been 16 sitting days in the first tier tribunal, 3 in the upper tribunal, a further day in the admin court in relation to parallel judicial review proceedings. Costs incurred over the relevant period on the main test case and the windfall tax challenge, net of cost recoveries from the revenue, are in excess of £9.8 million.
But I thought Mr. Ewart was saying that you were almost bound to incur these costs in order to win on your claims within the limitation period, whatever it was.
I think one of his points was that there's an issue in relation to shareholder credits, issue 17, and we could come unstuck in relation to that. But I think the view that's been taken in relation to that was that limitation, a limitation point that had been resolved in the claimant's favour was evaluated as being far more significant than any of the other issues.
I thought his point was that even if he succeeds on this appeal, your clients will still have succeeded in claims worth many millions, and they had to go through all the trials that I think you're telling us you spent the money on in order to succeed in those claims, to get the many millions that they win anyway.
The many millions, but representing 10% of what their claims would be worth.
No, that I follow, but here I thought you were making a point about costs being a prejudice to you if the appeal is allowed, and that's what I'm struggling to understand. If you're going to have to incur them anyway, suppose everyone knew at the start, let's say, that Herx was the starting point. I thought Mr. Ewart's point was, well, you'd still have been litigating in order to win the many millions that you win on that basis.
Strongest point. You spent 9 million rather than 5 million. It's not going to decide this case, I say. Sorry, I just suspected this may not be your strongest point, but whether you spent 9 million or 5 million, we're all aware that an enormous amount has been spent.
Well, and there's more in relation to costs I could say as well. Perhaps the best way of dealing with it is just to refer again to the summary of the claims by reference to the issue date. This is this is in the Respondents' additional documents, tab 2, so it's additional MS, page 4. One can see the quite starkly varying values of individual claimants' claims. There are some for whom continuing to expend costs may not have been a worthwhile exercise, others who stood to derive a much greater benefit from eventual success. So the pattern perhaps differs across the various claimants within the GLO.
Now, you're going to have to draw to a close, Mr. Margolin.
My Lord, yes. Conscious, I said I was going to deal with various principles of law. I think I'm right in saying that both the Jones and MBNA case and the Notting Hill Finance case, which refer to Singh and Das, are cited by the revenue, and those are in relation to the withdrawal of concessions and in relation to the taking of new points on appeal. I think the most up-to-date, or more or less the most up-to-date expositions of that, and I don't think there's any dispute between the parties in relation to those principles.
Can I just say, in response to one or two remarks in your submissions, that it would be quite wrong for anybody to think that the court's mind is made up. The fact that we put points that are troubling us to you to give you an opportunity to respond doesn't in any way indicate a concluded view, one way or the other.
I'm sure everybody.
And it's going to take us some time, I think, and a great deal of discussion to come to a concluded view on this case. We're certainly not there yet. Yes. Mr. Stewart.
My lords, can we get back to basics? That's another 1990 Conservative motto. In order to found a claim in unjust enrichment, the claimants must have made a causative mistake at the time of the payment of tax. They have pleaded and established that at the time of payment, they believed that the law was that the payment was due. But, in fact, at the time of payment, the law was that the payment was not due. That has always been their case. That's the case they've proved. This is not, in any sense, a deemed mistake or a Category 2 case, using our categorization. This is a Category 3 case. The law was, as they say it was, as the courts have now held it to be, at the relevant times. The problem that the claimants have is, if it were a Category 2 case, then in our submission, for the reasons that we've set out in our written reply, there would be no mistake at the time of payment. So the claimants would not be able to recover. Now, we do not say you have to necessarily decide that issue in this case, because this is not a deemed mistake case, and I can see that there are difficult issues that arise in truly deemed mistake cases. That is, cases where there was a decision of the court, which is then reversed subsequently, and parties in between acted on the basis of the original decision of the court.
That was my Anns and Murphy.
And exactly, and that's exactly the position that concerned Lord Brown-Wilkinson, particularly, I think, in Lord Lloyd, in Claimant Benson, if you remember. He was very concerned about cases where the Court of Appeal, I think his example, had made a decision, parties had made payments on the basis of it, and then the House of Lords, 20 years later, overruled it. But that is not this case, and it's actually a fairly rare, I would submit, case in practice. Most cases are like this. The law hasn't been established at all, and at some point, someone brings a case and establishes it. I say that partly because at some points in Mr. Aaronson's submissions, he seemed to be veering towards saying, in essence, this was a deemed mistake case. The law had changed at some point. However, he did accept, in the end, that even in 1975, a claimant could have pleaded an arguable case to recover the tax. He says that's not good enough in his test because you have to be, he says a prima facie case means a case which will succeed on the balance of probabilities. But that's his test. But what he did accept was you could have pleaded a case, an arguable case in 1975 because the law hadn't changed between 1975 and 2006. European law was exactly the same. It wasn't a case where the European Court has said in some point in the 1970s, you can't recover, tax law is not subject to European law, and then had overruled that decision later. That didn't happen. Nothing changed at all throughout the period. The second thing I would say is that the policy of the Limitation Acts is quite clearly to encourage early claims. It's not to encourage delay, which seemed to be what my learned friend was saying. You ought to construe the Act so that people can wait and bring their claims later and not bother the revenue or other defendants with early claims. But that's the precise opposite of the policy of the Limitation Act. The whole point of having limitation periods is to encourage people to bring their claims promptly. When you are considering whether there is sufficient material to consider bringing claims, then what you should be looking at in this case, in this context, is the simple issue in European law: is there a difference in treatment which arises, which amounts to a restriction? This is a matter of, another way of putting it is discrimination. Is there discrimination, a difference in treatment between the domestic situation and the cross-border situation? And as my Lord Reid said quite rightly, there have been cases going back into the 80s, in fact, but certainly through the 90s, where the European Court recognised that in case after case. I seem to recall in one of the earlier hearings, maybe about 10 years ago, my learned friend said that there was a case called Bachmann in 1992,
Yes.
which the revenue authorities succeeded in a defence, a particular defence. I think he said since then there had been over 100 cases where the revenue authorities had been challenged, and they'd lost every single one of them in the European Court. Every single case, the European Court had said that the legislation is incompatible with the treaty and therefore cannot be relied on. Going from 1992 right through to the 2000s, there's been more since then, I'm sure. Of course, it's true that defendants in such cases might raise counter-arguments, defences, justifications, but that doesn't, when I come to the test, that doesn't make the basic case unarguable. There's one perhaps simple way of testing this. The Hirsch case, my learned friend settled the writ, as he's told you. The Hirsch case was referred to the European Court by Mr. Justice Neuberger, long before the decision of the court. He clearly must have thought the case was arguable, otherwise he wouldn't have referred it to the European Court. So cases clearly, even involving European law, can be arguable long before they're decided. Can I then turn to AB in the Ministry of Defence and Sefton? In my submission, there isn't a tremendous difference between the tests in AB and in Sefton. There is a difference. I think in AB, the focus is on a period earlier than the period in which you would bring your claim. They talk about a belief held with sufficient confidence to justify embarking on the preliminaries to issue of a writ. So investigating it, etc. Whereas in Sefton, it seems to be focusing on having enough material to plead an arguable case. A case that wouldn't be struck out, we would say. With respect, we would suggest that the more appropriate test is the AB test. And that is because when you think about it, the beginning of the limitation period is not the time when you bring your claim. It's a beginning of a period of 6 years in which you can bring a claim. So you can bring a claim at any point in the 6-year period. Lord Walker adverts to this in AB, where he talks about after you have enough information to begin to investigate, you then have 3 years under the personal injury provisions. And he makes a point that seems like a long period, but in some cases it might not be long enough to do the investigation. But he accepts that the limitation period would start at an earlier point. But whichever of those approaches are adopted, it doesn't matter, we would suggest in this case. Now that doesn't help your lordships. But it's from our point of view, either means that we would succeed in a mistake of law case. Because the time in which you have a belief held with sufficient confidence, the time when you ought to have, or you could have the belief held with sufficient confidence to justify embarking on the preliminaries, certainly at that time, that would be a time long before proceedings were issued. in this case. But equally, the time at which you would have enough to that you should have come to the conclusion that you could plead a case, an arguable case, would also be a long time back. Put another way, if you think about it, the crucial date in this particular case is June 1997. Because if their limitation period starts to run before June 1997, then they're out of time. It's more than 6 years before. But what you have to think about is, well, can it really be said that the claimants could not have, with reasonable diligence, discovered that they were able to plead a case by early 1997? Now, we would say you can actually go back further, much further than that, but I think that's a useful way of thinking about it. What was the impediment to them pleading a case in January 1997? An arguable case, not a case that's bound to succeed, not a case that would succeed on a balance of probabilities, but an arguable case. My learned friend says that the key to AB is the fact that it's actually about attribution. That makes all the difference. But if you look at section 14, you will see that it talks about knowledge of various limbs. One of them is the attribution. Attribution means, in that context, causation. It's one of the elements that you have to prove to succeed in a claim in negligence. You have to prove causation. Just as in a claim in unjust enrichment, you have to prove mistake. So in section 32(1)(c), the focus is on whether you can discover that one element, the mistake. It doesn't talk about other elements. There are other elements of the claim, but you don't have to discover those. It's the mistake it's talking about. In section 14, the question is when you'd have knowledge of a number of elements, one of which is causation, essentially. But in both cases, the concept is the same. It's whether you would have knowledge or whether you would have discovered. So, and that was what the AB case was about. If you look carefully at Lord Walker's judgment, which I'm sure you will see he splits it into the different questions, the how question, the what question, etc. The first question, he's talking about causation, what the level of that is. The second question, he's talking about knowledge. And that's the issue that divided the court. What was the level of knowledge? The majority thought it was enough that you had a belief yourself, that you had sufficient confidence to embark on the preliminaries. The minority thought that you had to have objective evidence that would justify you in embarking on preliminaries. That was the difference between them. But neither, as I said in opening, neither the majority or the minority thought that the test was anything like Mr. Aaronson's test, that you had to be in a position that you knew that you were going to win on a balance of probabilities. It was a long way before that in AB. I think, as Lord Reader suggested, that this test would mean almost in every case of mistake, the limitation period would not commence until the end of the action. Because in most cases, the action itself will establish the law. So a claimant will say, I made a mistake of law. The defendant will say, no, you didn't. You were right about the law. You made the payment correctly. The matter will go to the Supreme Court, the Court of Appeal, and the law will be decided. And if Mr. Aaronson's right, in every case, the limitation period would be deferred until the final decision on the law. It would also mean that all other claimants in a similar position could wait until the decision of the Court of Appeal, of the Supreme Court, and then they could wait another 6 years almost before bringing their claims based on that. That would really simply extend the limitation period in effect indefinitely. Whereas the approach which we would urge would mean that in any case, the claimant would have to show that there was some reason, some impediment, if he could, why he could not have determined that he had an arguable case at an earlier date. And our submission would be in general that it would be not possible to do that unless there was a judicial decision to the contrary at the earlier date. Because it is difficult to think how, as a principled way, you could determine that question otherwise. Just taking the present case. How do you alight on a date at which, if you're taking some kind of factual approach, how do you alight on a date in the past at which claimants could have pleaded a case, an arguable case, with reasonable diligence? Assuming that you have to assume also, for the purposes of this test, that they are willing, that they desire to discover, you remember the mistake. So you're having to assume that there is somebody who's actually investigating it, because otherwise the objective test doesn't work. That's what Sefton said. So you're assuming a claimant who wished to investigate it, they took legal advice. I think the only possible way this could be done is by having expert evidence, lots of lawyers saying, what would we have advised in 1995? What would we have advised in 1993? Would we have advised there was an arguable case at some point? I mean, it's just, I'm not pressing you that approach on you, but I'm just suggesting that that's where the logic of the position leads. So unless you say what we say in our primary position, which is the law is always discoverable where it's not been decided by a court. If you don't say that, then you're left really at sea. My learned friend's submissions on the bar rules, my submission, it simply cannot, whatever the test is, it cannot turn on the bar rules for a number of reasons. The bar rules obviously can change from time to time. They have changed. So Mr. Ramson has now discovered. They can change. But also solicitors can plead. It's not just barristers. So why do you fix on barristers? In fact, the pleadings in the present case, you may have noticed, none of them are signed by counsel. Presumably they were all settled by the solicitor's firm. That cannot be the test. And it is addressing a different point. It's addressing a point of professional standards. The correct test must be whether a case, if there is to be a test of this sort, whether a case can be pleaded which will not be struck out. At what point could you plead a case that would not be struck out? The other problem, with the bar rules is that if you were basing your test on the existence of inadmissible evidence, first of all, how would the other side in the case ever know what this inadmissible evidence was? So how would they ever know when the limitation period commenced? And how could the court decide it, given the evidence is inadmissible? It just doesn't make any sense. The reason that barristers are allowed to plead on the basis of inadmissible evidence is simply part of the bar rules, accepting the practicalities that sometimes you do have to plead cases based on evidence that you know is there, but which cannot, at that point, strictly be proved and put in court. But it's not improper to do so, because you know that this is a proper thing to do. You've seen the evidence. The fact that you can't put it forward in a court is neither here nor there. It cannot be, my learned friend's interpretation of Sefton cannot be right. Otherwise, that would mean that one limitation period for fraud wouldn't start until you had sufficient evidence that you knew that you're going to win on the balance of probabilities, which could be long after you've actually pleaded and brought your claim. That can't be right. That's not what we would submit, what was meant in Sefton. It's not what a prima facie case means to anyone. It's perfectly possible to plead a case of mistake of law without having had the law established, so that without having it established so that you know that you made a mistake. A party can properly plead a case which depends upon an undecided legal point. That must be right. It's trite law. The case would not be struck out because the court would decide the legal point. It might be struck out if they decide the legal point was wrong, but it wouldn't be struck out simply because you have pleaded an undecided legal point. And that happens every day in the courts. It has become more of a feature, I think it's right to say, in the last 20, 25 years. On strikeout applications, I think in the past, courts would often say, well, this is a difficult point, we won't strike it out, we'll let you go to trial. Quite often now, they actually decide the point on the strikeout application, or it is attached with a summary judgment application, which allows the point to be decided. But in any event, that is a difference between fact and law. If you brought a case, if you brought a claim and you couldn't substantiate the facts because you didn't have the evidence, your case would be struck out. The court cannot, the difference is the court can generate, in a sense, the law, but it can't generate evidence or facts. So there is a fundamental difference in this aspect between fact and law. And that's really why Mr. Riordanson's point is wrong. It's perfectly proper to plead a case. Even in a fraud case, it would be proper to plead a fraud case so long as you had sufficient factual basis if it depended upon an undecided point of law. Any barrister, you could plead that. The court would then have to decide the point of law. But nobody would say you were breaching the bar rules by pleading a fraud case when you didn't have the material, in the sense that you didn't have the legal principle established in your favour. That's not what they're talking about here. What they're talking about is the factual basis that you have to have in order to plead. Can I then turn to Mr. Riordanson's example, which I would say quite vividly illustrates the difference between fact and law. His example was a painting. And this paintings illustrate the situations in which facts can be hidden. So the fact is, was this painted by Michelangelo or whoever? Now, we know it either was or it wasn't painted by Michelangelo. But it may be difficult to discover that. It may be hidden in the sense that the fact that it wasn't painted by Michelangelo may not be easy to discover. It may be you require technology to discover it. For instance, I think my learned friend suggested that there's another painting on the canvas, although it wasn't clear to me whether it was on the back of the canvas or on the front. If it was on the back of the canvas, then I would say the answer to his question is quite easy. They could have, with reasonable diligence, have discovered it immediately, simply by taking the back off the painting. If it was underneath the original the other painting, which is quite a common situation, because painters used to quite often use old canvases, which had paintings on them, then it's likely that it wouldn't have been able to be discovered until relatively recently, because there are now techniques for X-raying paintings and discovering what's underneath them. And so it may well be that with reasonable diligence, the mistake of fact as to who painted the painting couldn't have been discovered until a particular date. But that date would depend on, in one respect, advances in technology. So it might be said, well, you couldn't have discovered it until 2003, because it was in 2003 that we first started using these devices which allowed us to X-ray paintings and find this out. Or the other kind of example I think my learned friend mentioned is that they can now analyse the paint to discover what it's made up of, and they might be able to say, well, this post-dates Michelangelo by 200 years. They didn't use this kind of paint at that time, or vice versa. So that may be right, but that just shows that's questions of fact. You have to decide them. They can, whether you can actually determine it can change over time. The law is different, though. The law is not like a Michelangelo painting. The question about whether the law is X or Y is not something that needs to be discovered by technology. It's not something hidden. This was my point in opening. The law is open at all times to everyone. Otherwise, it wouldn't be law.
But robots can look at all the relevant previous cases much more quickly than humans.
Yes. Well, the answer to the question might change once artificial intelligence is introduced, yes. Especially if there's artificial intelligence judges who can addressed by artificial intelligence barristers. Could be an interesting experience. Can I deal just briefly with Littlewoods and Prudential? My Lords Lord Reid and Lord Hodge will know, because you were parties to both of these decisions, you will know that my learned friend is wrong to say that the construction of 32(1)(c), whatever it is, made a difference to the decisions in those cases, to the issues. In Littlewoods, the Supreme Court held that all common law claims were excluded by Section 78 of the VAT Act. That was the first question of point of construction. And secondly, that European law did not require compound interest. And that was the end of the case, really, because UK law provided simple interest, and that's all that was required by European law.
It's interesting, actually, because on a literal interpretation of a relevant provision, it would have included common law claims. And it was interpreted as not including them because that would undermine the purpose of the provision.
Exactly, yes, yeah. But it is what is true. I can concede is that the revenue could have raised a backup issue. They could have, because their case was Section 78 excludes all common law claims. What they could have said was, alternatively, if that's wrong, then Section 32(1)(c) doesn't help you either for the reasons that we're discussing. But that would only have arisen if they were wrong about Section 78. They could equally have raised the prudential point, actually, when you think about it, because what they were looking for was compound interest as restitution. So if they'd anticipated the Sempra point, they could have raised that as well in Littlewoods. But they didn't. They were happy to win on a different point. Similarly, in Prudential, the basis of the decision in Prudential is set out clearly in the head note. I don't think I need to take you there, but it's based on the law of unjust enrichment and the fact that in the Prudential case, there wasn't a transfer of value. What happened in Prudential was the revenue held on to money that had been paid unlawfully.
Well, the key was that the law of unjust enrichment had moved on since the Sempra decision.
Yes, exactly. But the reasoning didn't depend on 32(1)(c), in any sense. And it would have applied within the 6-year period as well as outside the 6-year period. So it was a general decision.
Yes, and in Littlewoods, the point, 32(1)(c) wasn't really the problem. It was that the normal limitation period was only 3 years. I mean, there were 2 points. One was, under the statute, you only got simple interest, and the other one was you had only 3 years to bring your claim. Whereas, if common law claims...
Yes, I think it was actually about there was a period, wasn't there, in Littlewoods, because they were able to claim further back because of European law, I think, or whatever, and they were able to claim within the period, but there was a dead period. Right. There's a sort of dead period. Yes, they weren't able to claim it. Yes. Can I then move on to the legislation? I can just deal with briefly. I've dealt with it in opening. I don't really have much more to say. There's no doubt that the legislation was Section 320, Section 107, and the restitution tax were Parliament's response to the court decisions in DMG, etc. Section 320 was actually enacted during the litigation of DMG, so I think before the Court of Appeal decision. So even as far as that's concerned, it hadn't been finally decided at the time that they introduced the legislation. 107 was just after. But it really is the opposite of the appropriate principle to say that where Parliament has legislated to ameliorate or attempt to reverse court decisions, that they should be taken somehow to have given them force. Parliament didn't like those decisions as a matter of policy. They thought they ought to be changed. In 2 of the cases, they were unsuccessful because of European law, but it's not an indication of approval of DMG. Can I then move on to the Supreme Court first time round? This issue was not before the Supreme Court. Is our submission. It was our submission in opening. The passages which my learned friend referred you to all concern the quite separate issue that is the Philip Higgins point. Is mistake required? And I would just remind you in this respect of what my learned friend said about this in their Court of Appeal skeleton, where they were keen to make the point then, paragraph 99, that what Lord Walker said, where he suggested 2001 was the appropriate date, it shouldn't be followed because he wasn't dealing with the issue. It was dealing with a totally different point. I showed you that in opening. And they were right. And in fact, none of what my learned friend showed you said anything about mistake of law or draw any distinction between mistakes of law and mistakes of fact. There was no question of issue estoppel or res judicata, as the issue was not before the court. Can I just in that respect take you to, because I think it's appropriate here, the Court of Appeal order the first time round, which is in Core Volume 2, page 114. It's, I'm sorry, I do have the...
It's 4159.
4159 MS. Yeah. And it's page 4160. It's 16. It is further ordered that. Now, my learned friend showed you Order 1 as it appeared in Mr. Justice Henderson's order. That's what's referred to as Order 1 here. But what he didn't show you was that order was actually amended by the Court of Appeal to say the following claims are successful, but A, insofar as, if you see, ACT was not paid, was not due after taking account of the tax credits, and 2, the claims are made within the applicable limitation periods. And the similar for B. So the order is that these claims are successful insofar as they are made within the applicable limitation periods. And that's the position. This order, actually, I think, is still in force, because when the case went to the Supreme Court, this particular order wasn't varied. Because all the Supreme Court decided was Section 320 and 107 were invalid. But they didn't decide anything about the limitation periods apart from that. So that was the, if you like, the position when the case went to the Supreme Court the first time round.
But that order would have been made in the context that HMRC had conceded that BAT's claims were in time.
That's not at that stage.
No?
That was after. That was in the second stage.
That was only in the second stage, I see.
Yeah. The common ground point was in the order, the second stage order of Mr. Justice Henderson. And what I say generally about a lot of the points that are made about what was said below and what was common ground is, it was all said below and all common ground on the basis of the law as it stood then, as it stands now, in fact, as we stand here. The law being DMG. So all of what was said was, in my submission, correct. And as I said in opening, these points that we're debating today could not have been pleaded or argued below at the trial or the Court of Appeal hearing. So neither of those would have gone any differently. Could have gone any differently.
No, but you could have reserved the right to open up DMG in front of his court.
I think that is all. That is what could be said. It could have been said expressly.
Yes, and given the sums involved in this litigation, it is, put at its lowest, unfortunate, is it not, that notice was not given.
It could have been said, yes. Although yes. I think it's fair to say that it would have been assumed that everyone would know there's a possibility that if the case went there. And I did point you to the passage in the Court of Appeal where we were discussing a mistake, and I did say, of course, if it goes to the Supreme Court, things could be different. I didn't really think it was a point to make, but if I'm wrong about that, I apologise. We could certainly have said. But of course, what we'd have been saying is, well, if we ever get to the Supreme Court, then things might be different.
You've been there before. I mean,
Sorry?
You've been there before. I mean, before the last.
Yes, but well,
you
certainly in my mind, not on that issue.
No, but I mean, one would have thought it might have been courteous, at least to the court, to say, and by the way, none of this really arises because we're going to challenge DMG.
Well, we're going to try to. Well, we might try to if we ever get permission. Yeah, to get to the Supreme Court. Yeah. But the question, I suppose, the question for you is, what difference does that make to this issue, which has been ordered to be heard?
Oh, yes, I mean, you say we want to hear it because it's always a live issue, but we also kept open the fact that this has caused prejudice or barred for other reasons.
Yeah. Oh, yes, I understand that. But I'm addressing the abuse point, I suppose, here, which is really what you're getting at, which is to say, can it be an abuse? First of all, it was ordered. Then also, you will notice Mr. Justice Henderson didn't think it had been decided previously, and that was what he thought when he was asked after the hearing. So we certainly were justified in thinking that this was a point that was new and open to everyone to argue. That was what we thought. That's what Mr. Justice Henderson thought as well. Well, you can see that in his second judgment, where he makes,
Yes, but I mean,
makes a point.
we can go on sort of looking through all these things, but
Yeah.
the substance of it is that everyone assumed that this point had been admitted and was not a live issue.
Well, I think the best that the claimants can say is that they thought that as regards BAT, and arguably the other one's the same, that there wasn't an issue on limitation. There clearly was an issue on limitation with the other claimants.
Yes, is it 19 or something? No.
Well, there's 9 or 8. depending on
9 or 8, yes, but the 2007 afterwards.
Yes.
Yes.
Plus the ones that are outside the GLO. That I think.
Because issue 28, as initially framed, was addressing 2001 as against 2006.
Well, it wasn't strictly. It was a general issue. It was asking what was the date. It didn't. It could have said is the date 2001 or 2006. But
Yes,
it didn't.
I agree. But if you look at it in context, with the concession having been made,
Well, that's right. But below, yes, that's right. But below, it could only have been really because of DMG. I think everyone accepts that DMG decided it's some decision. So you have to identify a decision. That was what DMG said. Now the odd thing is, although they say it's an abuse to bring this, my other friends accepts that that's not correct. I mean, they're accepting that the DMG test is wrong. That it's not correct to say you've got to look for a decision because the law has changed. He says you look for a prima facie case, although he interprets that in a rather strange way.
We're dealing now with a different point. I mean, I don't know that you've got onto it, but I mean, the prejudice points they make is that BAT would never have appealed this point because it didn't arise in their case.
Yes, well, yes, and the response to that, well, we had a number of responses. One is that's not the kind of prejudice that you normally be looking at in cases where you're asking, is this an abuse? The question would be, would things have gone differently below? But even if you are, then other people can appeal. I think we pointed out that the other claimants who were affected could have appealed. One assumes that they would have to be separately represented at that stage if there was a clash, thought to be a clash between the position. But they could certainly have appealed.
But there's a more general point, isn't there? I mean, these proceedings have been complicated enough for everyone, and it's a miracle that somehow one sees the extraordinary achievement of all the parties and Mr. Justice Henderson and others in actually getting us to where we are now. But surely it does depend on a degree of discipline about deciding which issues you are going to take, particularly from the revenue.
Yes, well, that's true, but this is this is not a point that we're taking out of the blue. This is a point that arises on the issue that is here. I mean, the difficulty with all the arguments is where does that lead? Does it mean the issue shouldn't have been tried at all? Because after all, the claimants want the decision on the issue. They've got a decision in their favour from the Court of Appeal. They were very happy to take an appeal to the Court of Appeal to establish the position. It's a very odd case to say, I mean, usually you would be saying in these cases, well, you can't bring this claim. That's the normal Henderson thing. But I think they cannot be saying, well, you can't argue this issue because this is an issue that's been decided, has to be argued. They can't be saying you must argue the issue on a false basis. If your lordships were to decide that you didn't think DMG was right, as I say, we've pretty much got common ground on that. If you were to say you didn't think DMG and Claimant Benson were right on this point, is it being suggested that somehow you can't do that and that you must decide issue 28 on a false basis? Well, that can't be right either. I mean, the fact is we're here on an issue that was ordered and agreed and has come up through the courts. It's not like a case where we suddenly come up to the Supreme Court and say we'd like to introduce a new issue into the proceedings, which is to some extent what's being suggested we should have done the first time around, that we should have brought a new issue in the first time in the Supreme Court and said, hold on, we want you to decide this other issue, which hasn't been raised before below, but we want you to decide it. And there isn't the demarcation that my learned friend suggested between liability and quantification. If you think about the issues, you can see that. But Mr. Justice Henderson himself, in the second judgment, you'll see at paragraph 4, says there are a number more issues of liability and quantification to be decided. So there isn't that differentiation, truly. The issues that are being decided on the second stage include issues about enrichment, issues about change of position defence, issues about limitation. I don't know whether you call that quantification or liability, but it's probably neither of those in a way. It's a defence. So all of these issues are being dealt with. Some of them are still live. So there clearly wasn't that demarcation. We couldn't make that demarcation because we didn't know in 2007 what all the issues were going to be. And if we tried to produce a trial for Mr. Justice Henderson with 50 issues, which is about the total of the number of issues between the first and second stage, I think he would have said, this is going to take me too long. This is beyond the wit of man, really. It's quite an amazing feat. Tribute has not been paid before, but it's quite an amazing feat that Mr. Justice Henderson produced judgments in these cases on his own. At least in the Court of Appeal, they've got 3 people to produce them. But they are an amazing feat.
Is there an assigned successor to Mr. Justice Henderson?
Yes, Mrs. Justice Falk, at the moment. There have been, the Chancellor was for a short time, but he managed to, realising what was coming. But it's Mrs. Justice Falk. But there's not so much to do now, although I thought there wasn't. There are still bits and pieces around. Yeah. Can I just then take, sorry, see, I was dealing with FII, the Supreme Court first, and then I was going to move on just to briefly, very briefly, given time, talk about the Law Commission report. Now, the Law Commission report is yes, it is a very long and very detailed and very excellent piece of work, but it's not about restitution primarily. And in fact, when you look at it, there's only very small paragraphs out of 300 pages about restitution. It's mainly about other things. There's a lot of very difficult and knotty issues involving limitation with historic sex abuse cases and things like that, which are all discussed. Lots of things are discussed. Restitution is quite a small thing. When you actually read the passages, you see that there really hasn't been a very deep analysis of the kind we've gone into in the last 3 days. This is not a criticism of anyone. I think what happened was Claimant Benson was decided not long before, and it was probably regarded that's the law, so there's no point in thinking deeply about what the law ought to be. But
the object of the exercise was to produce a sort of coordinated scheme.
For everything.
For everything, sort of replacing a whole lot of disparate schemes. That was the idea.
Exactly, yes. But I don't think there was I couldn't find any discussion about knowledge in the context of law as opposed to fact. That doesn't really seem to be discussed. There is a paragraph which raises it, but it raises 2 issues. One is cases where you get legal advice, which is negligent, and cases of mistake of law. The subsequent discussion is all about, as far as I can see, the cases of negligent advice. And the question is, well, how should you treat law in that? At what point should the claimant be taken to have discovered the law or have knowledge of the law so that they know they've got a claim? But I can't find any discussion, couldn't find any discussion of the issues we've been talking about as to what a mistake of law is and how that works. In any event, you might think, my learned friend says, well, a 10-year backstop is perfectly reasonable. What about a 6-year backstop? That's perfectly reasonable as well, and one might have thought. That would be the consequence of, I think, the arguments we're putting forward. 6 years is quite a long time. quite a generous limitation period internationally. I think Lord Gough talked about a German limitation period of about 1 month, didn't he, in the Claimant Benson. But 6 years is pretty generous. So you might think, well, why 10 years? Once you accept the concept of a backstop. Can I then briefly deal with my learned friend's arguments on issue estoppel? We say in summary, issue estoppel and cause of action estoppel only apply where there is actually a decision of the court on the point. The extension of the issue where matters were not actually decided but could have been, etc., are all covered under the Henderson. And you can see that in the way the courts have dealt with them. Although they refer to them perhaps as issue estoppel or cause of action estoppel, they then go on to justify them on the basis of Henderson. And we would say that must be right in principle, because it's one thing to say there's a hard-edged principle that you can't argue a case where it's been actually decided. It's quite another to say there's a hard-edged principle where it might have been decided or it might have been argued. In those kind of cases, it's more appropriate that you're looking at it on a wider merits-based approach of abuse, as to whether it's an abuse to take the point now, when it could have been taken at another stage.
It does seem very strange that Henderson stretches within those two estoppels and also outside.
Yes.
Much neater to say the two estoppels cover territory A and Henderson covers territory B.
Yes. I think I would agree with your lordship. After all, if you don't find there's an abuse, why on earth shouldn't the point be litigated if it hasn't been decided previously? It's only if there was an abuse. It's an abuse to argue the point or to take the point now. Just on what slightly vexed me, my learned friend took you to a passage where we were arguing, I think actually it was with Lord Reid the last time round, and I gave an example about overruling DMG. Now, what we were talking about at that stage was the difference between retrospective decisions of Parliament and retrospective decisions of courts. And what I was saying was, European law doesn't like Parliament retrospectively changing the law and removing rights. But if the court were to remove rights in the sense of change the law from what it had declared before, European law would have nothing to say about that, because the European court understands the declaratory theory of law. That was what the debate was about. So I wasn't conceding DMG, and in fact I don't think we were focusing on 32(1)(c) part. We were focusing on the main part question about whether mistakes of law and tax were recoverable. DMG had decided they were, and I was simply saying as an example, supposing you were to reverse that, of course all their claims would collapse. But European law would have nothing to say about it. I'm not sure what the rest of that argument was. I'm sure it was all to do with Marks and Spencer's and retrospectivity.
On the point you just made about the hard-edged principles of issue estoppel, cause of action estoppel, and Henderson abuse, do you have anything more to say about paragraph 24B in Mr. Justice Henderson's order, MS page 4185? Are you coming to that?
I was just about to talk about 24B in the last 2 minutes.
The reason that I'm raising it is that it might be said that that does look like the sort of terminus of that issue, so far as the BAT claimants are concerned, in the litigation.
Well, the first thing I would say about it is it clearly only applies to the BAT claimants, whatever it does. And that's clear for the reasons we've stated. It's only a common ground in relation to the BAT claimants. But what we say about it is it has no more effect than any other agreement as to common ground. It's not a matter I would submit it's not a matter we could have appealed, because it was true. it was common ground before the judge, because that was the state of the law. So there's no doubt that that was correct. It's not a matter. A record of common ground is not something that could be appealed. But it doesn't raise cause of action estoppel or anything like that, because it's an agreement. Now you could say, well, we should be held to it because it's only fair. We should be held to it. We would ask that we were not held to it, but if you're holding us to it, it would be because you regard that as being fair, and it would be wrong for the revenue to go back on it.
But that issue would arise, even if one sweeps aside the estoppels, and even if one says it's not precisely within Anderson and Anderson, we still have a case management issue. You are applying to amend your pleadings, and we can have regard to 24B in exercising a discretion whether to allow you to do so.
Absolutely, yes. Our application to amend would be consequent, I think, on any decision you made.
Yeah, I was actually seeking to press you on whether it goes further than that, and that it amounts to an issue of estoppel. Suppose there was no appeal, and then 2 years later, the revenue decide, actually, we'd quite like to, in some way, relitigate this point. So the proceedings haven't reached a complete conclusion, and partway through, everything's moved on. 2 years later, the revenue say, actually, we just said it was common ground. It isn't common ground anymore. Give us permission to withdraw that concession or agreement. Would it really be possible for that to be done?
What you've got to remember is BAT have got a judgment, and that's being appealed. If there was no further appeal against the judgment, that would be the end of it, as far as BAT was concerned. The only reason this is live with BAT is because the BAT claim the judgments are still under appeal to this court.
But I thought that there had been no appeal against 24B.
Not against 24B, but against what I mean is that if we didn't appeal against, I don't know, if the matter became settled in this court, or there's no appeal against the Court of Appeal decision, then BAT's judgment would stand. It couldn't be reopened.
Yes, thank you.
Yeah, that's because that's the position of BAT. The other claimants are not in that position because they haven't got judgments. They haven't. Well, there are some summary. Can I just make one point? The summary judgments. The position is complicated there. There are some summary judgments that are under appeal to this court because they have been appealed all the way up from Mr. Justice Henderson to the Court of Appeal, and now I think we've been given permission on certain grounds to appeal them further. There are some other summary judgments which have been stayed. I think these are the ones possibly my friends are referring to, by the Court of Appeal. We applied for permission to appeal just to keep the matter open because they're affected by this decision, by this litigation. That's been stayed pending the decisions of this court. So they're all still there, the summary judgments, procedurally, anyway. They're only on, I think it's right to say, they're only on the FID issue, they're only on part of the claims for historic reasons. I think that's right. There may be some broader ones, but basically Mr. Justice Henderson gave judgment, summary judgment on the FID issues because he regarded that as having been concluded, though he didn't think any of the other issues had been concluded at that stage because they were still under appeal. So that's why there are these summary judgments, which you may see referred to somewhere, which are still under appeal.
And in this present appeal, is it only the BAT group claimants to whom issue 28 is material? No. Issue 28, when we have the BAT group, we also have the Ford group and the GKN claim. And issue 28 is not confined to the BAT group.
No, issue 28, well, on one view, it affects everybody in the GLO. Ford is a test claimant because they have a particular point.
Yeah.
GKN were a test claimant because they raised a particular point,
yep.
But they've dropped out now because their point has gone away.
Oh,
so they're effectively just one of the follower members of the GLO. Now, I think that'd be right. but the issue potentially can affect all of them. I try to divide them up, if you remember at the beginning, between the 8 or 9 that are affected by whether it was before 2001 or not, and those who are not affected by that, and the back claimants, who might be in a different position because they have got their own judgment and order, etc.
Yes.
So there may be a distinction between those.
Thank you. Well,
I think that's probably, yeah. I think there's not much more I can say.
well, we're very grateful to counsel. As you'll have appreciated from our interjections, we're finding this very interesting, but also very difficult. And we'll take time to consider all that's been said and written, and you'll have a judgment in due course.